The Socio-Economic Rights and Accountability Project has filed a lawsuit in the Federal High Court, Lagos, against the Code of Conduct Bureau over the latter's claim that it could not disclose details of asset declarations submitted to it by successive presidents and state governors since 1999.
The CCB recently refused the Freedom of Information request by SERAP, stating that asset declaration form is private information. But SERAP says the CCB does not have reasonable grounds on which to deny its request, as the Bureau is bound by the Constitution to make such information when it is requested for by Nigerians.
SERAP further added that its request is in the interest of the Nigerian public, transparency and accountability. So joining me now is the Executive Director of Socio-Economic Rights and Accountability Project, SERAP, Adetokunbo Mumuni. It's glad to have you join me right now. Nice to see you, really.
It's a pleasure. Yeah.
Now, talk to us basically. The CCB, as established by the Constitution or recognized by the laws, is in trust for the people, for the public. So if the people, the chief executives or any public official decides to, declare its asset to the CCB, isn't that to the public by implication already?
As a matter of fact, what the law that we presently have says is that any information or documents in the custody of a public officer or a public institution is accessible to the public once the necessary demand for it has been made. So to now say a declaration made by past governors, past presidents, is now a private information is not so, because the Constitution has said these are public officials entrusted with public functions, performing public duties. So you cannot now say the declaration that they make is now a private
How important
matter.
Is the knowledge of what asset is being declared or liabilities? Of what importance really is that to the public as a whole?
You see, we have seen as a matter of repeated occurrence that these public officials, whether politically elected or politically appointed, what they will say is either they declare false assets or they do what we call anticipatory declaration. What they do is deliberately to lie, and what they intend to achieve is by the time they are in public office, they will now start acquiring properties to meet up what they have declared. So that, you see, the Code of Conduct provision in the Nigerian Constitution is not there for fun. It is there so that Nigerians, coupled with the promulgation of the Freedom of Information Act, is there so that Nigerians can interrogate whatever forms they feel or their declaration. So that if you tell us you have this house at a particular place, perhaps members of the public can go to the location that you say and verify whether such a house exists in the first place. And if the house does not exist, they will raise alarm. At my friend, you say you have this house at number so.
But we often don't hear the raise, like you use the word raise alarm. We often don't hear the raising of alarm until such public official has left office, sometimes for a few years, sometimes for many years, before we hear issues of discrepancies between what was declared and what was in the form.
That should not be the purpose of the law.
Okay.
The purpose of the law is to pin the public officer to ground so that whatever declaration is made, we will make sure, Nigerians have to make sure that these are in fact truthful and sincere declarations, so that they are not made anticipatory or deliberately false.
All right. Now you decided to sue the CCB for saying that they will not make the declaration of the content of the form public. What are the prayers you have in your suing?
Now you see, when you make a request under the Freedom of Information Act to any public official or any public institution, the expectation is that once you meet the requirements of the Freedom of Information Act, there is no problem. Now that the CCB has said, what if they make that information available to us, it amounts to violation of the privacy of the governor and the president. We are now saying, no, that is not so. Let the court, because we, under section 2022 of the Freedom of Information Act, you have a right to go to court within a month after your request had been requests have been refused. So sometimes your request may be deemed refused if no communications gets to you within 7 days of your request.
Okay.
Your request may actually be refused if they communicate to you and say the reason. And what we now have is our request has been refused because they told us that they won't be able to give us information for this reason.
All right.
So we want to go and test that issue in court so that the court will now tell us whether those information submitted by these public officials are private
or public.
Why are you doing this now? Why is SERAP doing this now? And how is this of interest to or of benefit to Nigerians?
And that is the work that SERAP has taken up. SERAP is socio-economic rights and accountability project. How do you make Nigerian political office holders, Nigeria's appointed public office holders accountable? Now, the content of the Code of Conduct Bureau as allowed by the Constitution is not there for fun. We have to make our law count, and it is in making our law count that we have decided to use the Freedom of Information Act, which has made it compulsory for every public official or every public institution.
But the same Freedom of Information Act also recognizes privacy, just like the Bureau has said.
You see, once you have been christened a public officer, there is no way the information that you filed as an asset declaration form before the Code of Conduct can be a private matter again. That is the point that must be made, that must be clearly made. It is not as if, you see, once you are a public officer, the Constitution has said you are a public official. So you cannot, as a public officer, now be making a private statement. It's not possible. And in any case, what we are saying is that once that information or document is before a public institution, the Code of Conduct Bureau, then it should be made available to the public once it is made.
Because some persons are saying this action by SERAP is just reactionary. It's not, there's nothing extraordinary to it.
I don't understand what reactionary means. What I know is that the law exists, Freedom of Information Act, and it has said Nigerians should demand for documents or information. And once it is demanded, it has imposed a duty on the public official or the public institution to make the information available to Nigerians. So what is bad if SERAP says that our law must be made enforceable, our law must count, a law that is geared towards transparency and accountability in respect of public officials must be made applicable.
So now that the issue is at the courts, what next?
No, because we have made our own demand, we have filed our own case in court, let them come and argue that
aspect of privacy?
Invasion of privacy before the court, because we know that, you see, the categories of information that cannot be disclosed are clear by the Freedom of Information Act. They are clear. You see, for example, SERAP does not have a right to make demand for matters relating to defense, matters relating to, for example, the test for examinations. Those are the categories of information that are closed. So the only ground that the CCB can be telling us that they won't release information to us are the grounds provided for by the Freedom of Information Act, not any other ground.
So what are you looking forward to now at the courts?
No, what we insist that must happen is that a law made for transparency must allow for transparency. A law made for accountability must allow for accountability.
All right.
A law made for the interest of Nigerians to know. In a democracy, Nigerians deserve to know.
All right.
That is the point we are making.
All right. Adetokunbo Omuni, Executive Director of SERAP, thank you for your time on TVC Breakfast.
It's a pleasure being here. Thank you very much.